Hello everyone and welcome to IBE classes. Now we are going to discuss the second test of paper 2, right? So the second test of paper 2. And in this what we are going to discuss is about the polity as well as the governance question that were asked, right? So in our previous video, we have talked about international relation, and in this basically we will be talking about the polity and governance question. Now coming to the question, the first question that was asked was discuss the role of political parties in the Indian political system, right? So if we talk about the Indian political system, obviously it is a democratic based political system, and in democratic based political system, in India, we have multi-party system. So when in India we have multi-party system, so first thing that the multi-party ensures that a lot of diversity is being catered by them, right? So all the diversity in demands and aspirations are obviously being fulfilled by this one, right? This is the first thing that you could write. Now, apart from this, they play a significant role in establishing true feature of a democracy, right? So the voices which are completely unheard, now they get heard. The regional aspirations, they get promoted, and they are bring forth by the political parties in the form of different agendas and all, right? Apart from that, when we talk about the political parties, now the political parties have play a very significant role in ensuring the true nature of federalism, right? So federal structure they maintain, right? It is by sitting in the opposition, obviously they regulate the executive, right? And the executive action, they have a strict check on the executive so that they could perform their function and they don't become a dictator. Apart from that, obviously, through bringing a no confidence emotion, they can even bring about the collapse of the government if the people have lost their faith in the government as such. Right? So they are the people who are the policy maker of the country. They are running the countries. So it's the political parties all around that is playing a significant role in ensuring a true nature of democracy, and obviously for ensuring cooperative federalism as well. Apart from that, the tribal aspiration, the downtrodden aspiration, the social inclusive questions, etc., are well catered by the political parties, right? So these are the things which you need to write in this question. What was quite a general question that was asked here. Now we will move on to the next question, that is, what is Citizens Charter? Now, what is its role in the welfare of citizen? Now, when we talk about the Citizen Charter, right? Now, the concept of Citizen Charter came into being in 1991 for the first time in United Kingdom, and there the Prime Minister John Major was the first person to introduce it. Now, the question thing is, now the question is, what is basically citizen charter? Citizen charters are basically declaration of the services that are given by the government agencies or government agencies or any company or anything. It means it is only for ensuring this thing that the information, whatever the services are being given, right, that should be transparently conveyed to the people, right? Apart from it, it has been made mandatory that all the government service providers, right, and the offices should display citizen charter in the basically at the entrance of their office, right? Now, citizen charter, as we know, it says what the services that they provide, what are the ways of grievance redressal to those services, what are the time frame for the services and all, right? Now, obviously, these are the things which are mentioned in the basically citizen charter. Now, citizen charter has been, taken care by, there is one nodal agency for implementation of citizen charter, and that is Department of Administrative Reform and Personal and Grievance Redressal, right? So it is DARPZ, which is responsible for it, and it ensures that all government agencies which are providing government services to the people obviously abide by the citizen charter. So it uniformly applies to all the services that are provided by the government, and it has been made mandatory to display it. Now this is citizen charter, what you will write. Now the next question says, what is its role in welfare of citizens? Now, when we talk about the welfare of the citizens, obviously it plays a pivotal role in that. Now, how it does so? First of all, it promotes the transparency, right? So, because all the data, all the services are clearly conveyed to the people, so the transparency is maintained in it. Now, the second thing is obviously the accountability. Now, accountability obviously becomes important because if those services are not provided by the government, obviously the government could be held accountable to that, right? So again, the second one, accountability becomes there. Now, third one is the redressal of the services, right? So the redressal of the grievances pertaining to that, obviously they have to mention the grievance redressal also. So this ensures, obviously this ensures that what we do is obviously we need to redress the grievances. So this is very important if the services are not made. And the fourth one is timely delivery of the services, which is done by it. Now, timely delivery of services, we have the Timely Delivery of Services Act 2011, right, which says that there should be a provided time frame given under in the citizen charter, right, which should ensure that every service or every grievances are redressed within a prescribed time as such. Now, if an RTI is obviously used for this one, obviously, right, if certain hidden citizen charter is there, right, so it's not made public, right, so obviously this is what of all you need to write. Now, we will talk about the third one, discuss the impeachment process of the president and how it is different from the removal of the judge of High Court and Supreme Court. Now, coming to this question. Now, so first of all, impeachment of president. For impeachment of the president, obviously, the move or the resolution first difference is in terms of ground. Now, in terms of ground, the difference is basically only for unconstitutional work or working against the constitutional norm, where the president can be impeached, whereas the Supreme Court judge or the High Court judge can be removed from its office on the two bases. One is misbehavior and second one is incapacity. The first difference is this one. Now, the second one is obviously the resolution for initiation, right? For resolution, the initiation of the resolution for removal, basically, that is quite different in both the cases. First of all, in case of president, it requires 1/4 member of the house to sign that, then only it could be accepted by the speaker or the chairman, right? Whereas in case of removal of judges, it is 50 in case of Rajya Sabha and 100 in case of Lok Sabha, right? So that becomes very important, right? So this is the other ground how the resolution, get accepted, right? Here also the mechanism for resolution is different. Third one is in the process of adoption and now the things done after it. Now, when the speaker or the chairman accepts the resolution in case of the impeachment of the president, he what he does it, if the thing is passed by two-third majority of the total seat. Now again difference is there, right? Now in case of impeachment of president, the resolution in that house when accepted by the speaker should be passed by two-third of the total seat or the total membership, right? Which is only in the case of president, right? Always remember this fact, right? It's not about two-third present and voting, it is two-third of the total seat, right? Now, but in case of right, first let me complete it. So, two-third of the total seat, it should be passed, and then the resolution goes to the other house. In the other house, what it does is the chairman or speaker of the other house, what he will do is he will constitute an inquiry committee to look into the charges made against the president. Now, at that time, President has the right to appear or put his point of view or put his, his stand on that very case, or he can even, nominate someone to go and represent him. Now, if the fact-finding committee, which could have a Supreme Court judge as well, right, it comes to a conclusion that, okay, fine, whatever the charges have been made against the president, they are completely true. In that very case, what will happen is, right, now the fact-finding committee will put forth the report in the second house, and then again the voting, and if passed by two-thirds of the total seat, then the president gets impeached. But in case of Supreme Court or High Court judge, obviously after the acceptance of, right, now after the acceptance of the resolution passed by 50 members of Rajya Sabha, if Rajya Sabha mein hoga to, and 100 members of Lok Sabha, the speaker or chairman, he himself, yani in the very first house only, he will constitute a committee which will have inquiry committee will be there, which will have three members. The first one will be the Supreme Court judge, second one will be the Chief Justice of High Court, and third will be obviously a renowned jurist as such, right? So these three people will be there in the committee, and if the committee comes to the conclusion, right, that okay, fine, whatever the charges that had been framed against the judge is completely correct, then only the voting will start. Now the voting should be majority of seat. Now remember, majority of seat means 50% of the total seat plus one, or and not or and two-third present and voting, right? So two-third present and voting, this is another difference. In case of president, it is two-third of the total seat, and here it is two-third present and voting, and it must be just more than 50% plus one is required of the total seat, right? So this is again the difference out there. One more difference is, in case of judges, the whole process should take place in one session only. If it doesn't take place in one session, obviously you need to reinitiate the things from the beginning, right? So this is another reason there, right? So this is the way, obviously, when passed by both the houses by two-thirds present and voting, as well as then obviously the High Court judges are removed. So there are a lot many differences in them, and some are very minor as such, right? So that should what you need to be writing in this one. Now question number 3, discuss the impeachment process that I have done. Question number 4, discuss the main methods by which the Parliament of India controls the executive. Now, this is a very question, the simple question is, as it was, as we know, the parliament, the first thing that you need to write is, it completely parliament controls the government or the executive, because obviously it is the whole council of ministers, right? They are directly responsible to the Lok Sabha, which is a part of parliament. So first of all, the whole control is there. Now, if the government is not doing their function, obviously, they could be removed by the by no confidence motions as such. Apart from that, there are different mechanism of control like the questionnaires. The questions are, as we know, right, like the asking question. The questions are asked basically in the questionnaire, then also in the 0 hour, right? Then they are short notice question. A lot many other things are there in terms of question, where by asking question, it keeps the government on toes and have a control over now the government. The second thing is through the motion. There are lot many motions like you have call attention motion. Now call attention motion is in the case when obviously if anything of particularly very important for the people has need to be discussed, so obviously you can call attention of the minister and you can get his official statement in that regards. That is for call attention motion. Then the most important, that is adjournment motion. Adjournment motion is a special case when anything requires immediate attention, and for that should be moved by at least 50 members, right? So it should be moved by 50 members, then only obviously the things called adjournment motion is implemented. Now this is important because it is only in Lok Sabha, right? And one more thing is there: once the adjournment motion come, every other business will stop and the discussion will go on this very thing, right? So this will continue, and this will be continuing, right, till the solution is reached. So it's a very important one, right? As we have already discussed, the no confidence emotion is also there. Apart from it, right, the government has to, right, implement those laws only which have been passed by whom? The parliament, right? So again, the parliament have a great control on it, right? So these are the things that you were supposed to write in this question. It's only 150 words, so that would needed to be written. Now, question number 5. To what extent has e-governance made the administrative system more citizen-centric? Now, e-governance means obviously electronic governance. Now, when we say electronic governance, it means that the use of ICT, Internet Communication Technology, as such, right, in governance. Now, obviously, for this, government has taken a lot many steps as such. It has, it has started giving all its services on the different portals and website. Now even the registration, entry and other things are done on the internet. Right now we have also through e-governance, we have also tried to use different media, social medias, as well as different platform for announcing the policies, as well as for making the citizen aware about the steps the government is taking, right? Apart from that, we have tried to create a citizens awareness about different social evils, against social evils, right? Or even the certain new employment generation program and poverty alleviation programs and all, right? Now e-governance has also been seen that we have tried to mitigate the corruption as well as the middlemen between the people and the government by obviously transferring uh, the benefits directly in the account of Jan Dhan Khata and all, right? So this is a very good step that has been taken. Apart from it, now from anywhere, any person can get his all the facilities, right? And he can even file his grievances pertaining to, because the government has provided a lot many websites and websites where the person can file its grievances and that grievances will get redressed as such, right? So these are the steps that has been taken in terms of e-governance. It is citizen centric because it promotes the transparency, right? Now every information is quite transparent. Everyone knows what the services government is providing. Then obviously when the person knows that that what services he deserves, right, then obviously he will be accountability will be there. Third one is inclusivity, right? The government is trying to give help to when those sections who has been marginalized in the society. So even equal access to them has been provided. That's why in the rural areas, the government has come up with a lot of rural broadband development program, right? Providing each of all and providing laptops and other to the students as a scholarship and something, right? So a lot many initiative has been taken in this regard also. Even for the redressal of public grievances, it is working wonder, right? So all these have contributed a lot to a lot in making the system completely transparent as well as citizen centric as such. So this was what you were supposed to write. Now we will come and talk about the long question and long question number 11. That is, Article 32 is the soul of Indian Constitution. Explain it through different writs jurisdiction of Supreme Court. Now, Article 32. If we talk about Article 32, Dr. Ambedkar has said that Article 32 is basically the soul of the Constitution, right? And his whole statement was like this. If someone asks me, right, which article is the most important article in the whole Constitution, I'm going to name only one article in that, and that is Article 32, which as per me is the soul of the whole Constitution. Right? Now, this was the complete statement made by Mr. Ambedkar. Now, when we talk about Article 32, it has been called the soul of the Constitution because obviously our Constitution has got the power from the people, and the source of power is obviously the people. And for the people, the most important right is the fundamental right. And as this article is the protector of right, or the uh, giving constitutional remedy for the infringement of fundamental right, that's why it is above all right, and it is the soul of the Constitution. You need to write at least 3-4 lines like this in the beginning, then you should go for the writ jurisdiction in all, right? Right? Now, we will also write here, okay, we have writ jurisdiction. Under this, there are 5 writ jurisdiction prescribed in the Constitution. And obviously, the Supreme Court is the authority as per Article 32, right? The Supreme Court will be issuing writ in case of infringement of fundamental rights as such. Now, when we talk about the infringement of fundamental rights, right, the 5 rights that is there is, the first one is habeas corpus. Or habeas corpus is basically to present bodily, right? So, in case of any illegal detention, either by the state or by a private person, obviously the Supreme Court can issue habeas corpus writ, and then the person should be presented before the detained person should be presented before the Supreme Court, and obviously the court is going to ask what was the basic reason for illegally detaining him, right? So obviously the personal liberty and life to Article 21, that is right to life, is ensured through habeas corpus, right? Second thing. Now, second one is mandamus. Now, mandamus is we command. Now, we command in what sense? Obviously, if the government is not doing its duty, right? So, in that case, obviously, this is issued by the Supreme Court that we command you to do your duties, right? Now, again, it is a protection of the right of life It comes under the right of life. So mandamus is also a mechanism for ensuring Article 21. Now we will move on to the third one, and the third one is quo warranto. Now, quo warranto means with what authority, right? Now, when a person holds the public office, right, and that too without having the required qualification, in such cases, what is issued? That is basically we issue this one, and that is called, when we talk about this, is called co warranto, and obviously the person is removed. Now in this, it is not necessary the aggrieved person is only going to file the case for that. Now even any person can file the case if he thinks that any public office has been illegally, you know, attained by someone, or someone has been posted out there. Now, fourth one is certiorari. Now, certiorari and the prohibition, the two are quite similar to each other. Now, in this case, certiorari, the certain differences have been created by the Supreme Court in this regard. And these, if we talk about these differences, now the first one is obviously it is ordered by the upper court to the lower court, and it is basically when any decision has been given by the lower court, right, has been given by the lower court, which is beyond its jurisdiction, then obviously that order will be cancelled, and that means it won't be certified. Certiorari means to certify. It won't be certified, right? Now, obviously, this is used in cases when lower court infringes its jurisdiction, and the Supreme Court can, or the High Court could obviously issue these writs and could cancel this infringement. Now, certiorari, we have also included now not only the courts but also the services, right? The government services or the government offices have also been brought under this. If any office, government office or any department infringes a jurisdiction, obviously the writs can be, the certiorari writ can be applied to it, and whatever the decision or the notice that has been served by that very agency will be nullified, right? So this is what it is there. Now, when we talk about mandamus, it is only in the case of court. It, unlike certiorari, which is also available in services, government services, right, government offices. Now, it is not applicable in that, only in court cases. That is, the upper court will prohibit. Mandamus, prohibition means prohibit, that means stop, right? The lower court, in which a case is pending or the things are going on, discussions are going on, and the higher court feels that now this thing with the case which is going on there is beyond the jurisdiction of that very court, then it prohibits, stop it, and transfer the case to itself. These are the five writs, and these are the different there. Now, when we conclude the answer, now when concluding the answer, you need to write that obviously Article 32 gives the constitutional remedy power to the Supreme Court in case of infringement of fundamental right. But Supreme Court, through its recent verdict, is infringing Article 32, because now it has said that no one could directly come and file in the Supreme Court in under Article 32. He should first go to High Court in case of infringement of a fundamental right, and then move on to the Supreme Court. But in recent case, basically, it was in the recent case, again, the Supreme Court has given a verdict. It was a case of Madras, right? And in Madras, a person has filed that, filed it against the order of the High Court, right? So he had filed the case in Supreme Court that oh, if I have appealed in the Supreme Court, right? So why that can't be directly heard? So in that case, it says that it is not illegal as such because the earlier bench has passed that order. This is why now this case was there. So इतना नहीं लिखना है आपने, बहुत सिंपल सा लिखना है कि obviously now the Supreme Court verdict is uh, in Article 32 is against the real norm of 32. Obviously, it has been done keeping in mind the plurality and the burden of cases that the Supreme Court has been facing. So it's not a very good as such because the soul is 32. Why then the soul will become 226 rather than 32, right? So थोड़ा सा इसमें इस एंगल से भी वहां पर बात करना है, right? You need to talk about this through this angle as well, right? Which is required in your answer because even the examiner should know that you have some certain insight about it, right? So this is there. One more thing is there key. Obviously, you should even write that Article 32 has been described by the Supreme Court as the basic feature of the Constitution, right? So even that should be written out. Now, after question number 11, we will move on to the question number 12. What are the problems faced by Election Commission as an institution at present? Also mention solution for them. Now, very important question. I'm expecting this question this year round to you guys. Right now, always remember one thing because the test, whatever the question we are asking, right, they are probable questions. So obviously even if you have not done well in the test or even if we're not able to do the test, right, or were not present, just do one thing, you know, obviously frame model answer for all these questions that have been asked in the test because those I had a hard, a very strong feeling that these questions are the ones that are going to appear out there. So we will see many questions, from the test directly appearing in the examination, right? So it is pertaining to all the subjects I'm telling. I'm not particularly telling about my subject. It's all the subjects that will be there, right? So that's why it's very important, get the model answers right written and all. Now, coming to this question, if Election Commission Article 324 of the Constitution has the provision of Election Commission. Now, if we talk about the qualification, there is no qualification prescribed for becoming Election Commission. Now, this is one of the demerit of the Election Commission as such. Now, the second thing is the appointment process. The appointment of earlier, the appointment was done by the president, right? And on the recommendation of the government, right? So obviously, it was basically a government agency. Then in Supreme Court, basically a PIL was submitted and in 2023. And obviously when the PIL was submitted and the Supreme Court took that PIL and on this Supreme Court gave the verdict that the appointment of the election commissioner should be as should be by a collegium system which will constitute of the prime minister, second one should be the opposition leader, and the third one should be the chief justice of the Supreme Court, right? So three members would be there and this collegium system will appoint whom obviously it will appoint the election commissioner and chief election commissioner. Now, after this direction given by Supreme Court, the central government introduced a bill and enacted a bill, and the bill name is basically the chief election and the chief election commissioner and election commissioner appointment and rule of services act 2023. Right now this was enacted and in this the government said that it won't be CJI. The collegium will consist of the Prime Minister, a Union Minister nominated by him, and the leader of the opposition. So these will be three member and there will be no judiciary involved in it. Obviously, the case has been recently filed in 2025, right? A case has been filed on the validity of the government's move, right? Now, obviously, this is what that has been done in election commission case right now. Now, the first question, the problem here is obviously if three members of collegium is there, the old system will remain because in three member, one is PM and one is union minister recommended by him. And if the majority decides this, obviously opposition will have no rule, right? So again, this system is basically a government, a government trap to keep the things, under itself, right? Now it has completely removed the CGI. Now this is again a problem that need to be looked into, right? So CGI was required. Obviously, if these three members would have been there, it won't be a government agency as has been criticized by many. Second one is in case of termination of the other election commissioner. We only have the process of removing the chief election commissioner through as it is taken, it is the same as the Supreme Court judge. But only on the mere recommendation and the government wish, the other election commissioner could be removed, right? And there is no definite terms being prescribed for the other election commissioner. This is a very, big issue out there. Third one has been in the recent election, especially in 2019, the model code of conduct had been infringed several times by the ruling party, and even our prime minister did that. Right now, when he advertised about anti-satellite rocket that India has developed, right? This was just before the election, and it is against the model code of conduct because it will obviously give a benefit to this ruling party. There have been many other instances of hate speech, right? Yogi Adityanath, OSC, and lot many people have been, giving hate speech against the Hindus, against Muslims, right? Which is, inciting communal feeling in the people, which is completely unconstitutional. But no harsh measure or anything was not done by the election commissioner, right? So this is why it is said that it is acting as a puppet of the ruling party as such. Now, next problem that is there is, right, it doesn't has its own financial independence. Now it things are not charged on the Consolidated Fund of India. It is basically the law ministry for which the budget is the Ministry of Law and of Law Affairs. So the budget is allocated for both these ministry at a place. So obviously there is a dependence on the government for money. So this can't be impartial. It doesn't have its own staff, and all the government staffs are used in election, right? So they obviously, most of them, they lack training. Whatever training that is given is not sufficient as such, right? Now, apart from that, we need a lot of security personnel, right? There has been a rampant corruption. Whatever the election commission has never been, you know, uh, able to regulate the parties, the party discipline within and even the party discipline outside, right? It's just merely confined to allocating them election symbols, right? Allocating them the party status, whether it is a national party or a regional party as a state party as such, right? So these are so many lacuna in the system that is present in election commission, right? So we need to reform them. Now reforming it, the first will be make the appointment process transparent by including CJI into it. So this will be your first recommendation. Now the second one is model code of conduct applies equally even for the prime minister, or as it applies to other people. So even the punishment should have been given to the prime minister for this. Third one is hate speech. No matter even prime minister says this, he should be, not allowed to contest the election, right? For giving hate speech, because if a person is giving hate speech, it is against the norm of secularism, which is the basic feature of our constitution, and it's a secular society. It's not a one religion dominated nation that we are in, right? So it's a secular one, and each religion and each faith of people are having equal share in India, right? Now, the third, next one we will say the financial autonomy should be granted and it should be separated from the Ministry of Law Affairs, right? Now, apart from it, we will see that VVPAT should be made mandatory, because even we have seen there have been often accusation of what obviously the accusation of tampering of the EVM and all, right? So to have the transparency should be there. So these are all things that you need to write. That's what the question that is all about. Now, next we will move on to the next question, that is question number 13. Discuss the challenges in center-state relationship, steps that should be taken for the cooperative federalism in the light of Sarkaria Commission report. Now, obviously, most of you have tried the first part quite well. They have, written the thing. The second part, most of you have forgotten what the Sarkaria Commission report was and what it recommended. Now, if we talk about the problems, the problem between the center and the state is not a new problem, right? Right from 1967, when the states started having, right, different government than the center, right? Then from there, the center-state relation has always been a center topic which has been, marred with controversies. Now, the first thing that is the center focal point, and the first point we will talk about the post of governor, right? Because governor acts as the agent of the center, and if different parties are in power, so obviously in that very case, right, governor is quite a draconian figure for the state government, right? We could see it in the case of Delhi, where Kejriwal was unable to implement anything due to LG was from BJP, and he thwarted all his effort for any reform or anything, right? So this was there. Now we will also talk about the second point. Now the second point is obviously the financial dependency of the state on the center, right? Where we will see that the residuary powers are completely vested there. Apart from the union list, the concurrent list also taxes could be there. So this is one thing that need to be there. Now, Finance Commission is, constituted by the president, who is obviously the government again, right? Now, this is why there has been completely, a financial dissimilarity between the state and the center, and states have always raised their voice against it. For example, if we look at the recent trend, the government, as per the recent report of from 2019 to 2024, the maximum investment by the central government has been in the states that is ruled by the BJP, right? Now, in the states that are from the opposition party, like the Kerala or the West Bengal, right, and other, right? So there the investment has been very less. Now, this is again, this is such a problem for our federalism, cooperative federalism that we think of. Now, the imposition of a president rule in the state is also a big issue, because often it is used against the political party of opposition by the government, right? So, this is again a problem. Apart from it, the All India services that is there, which the appointment is made by the center and the person works in the state, again is problem because they tend to act as the agent of the center there, right? So they will give more importance to the central thing rather than the state thing. So this is also an important problem with which in the center state relationship we see. Now, obviously, if the need of the hour is a cooperative federalism, right? Now, cooperative federalism is required, and for that, the Sarkaria Commission recommendation needs to be, implemented. And what are the reports and the implementation are? For obviously harmonious relationship, interstate council should be established, and you should write there that it has to be in present case when it is established. It should be more effective, right, and more inclusive in nature. Now this is what you need to write there, right? Now the next thing is obviously article 356, that is the state emergency or the precedent rule should only be the last resort, right? Otherwise it should never be imposed on the state. Now this is there. In case of governor, obviously a person who is non-political in nature or a person who is not from the party of the central government should be there, and it should be from outside the state. Apart from it, he should be given, you know, due security of 10 years so that he could act independently rather as the agent of the center, right? Now, all India services should be increased more and more so that this feeling doesn't come to the state, and all state will have equal mechanism or the trained staff who have better training than anyone else, right, in all the states, so development could occur. So a lot many recommendations over there of Sarkaria Commission, right, which needs implementation even to do. Right? So this was what you need to write. Now question number 14. Discuss the challenges now that we have done. Discuss good governance and the factors required for it. What are its challenges and how good governance could be attained in India? Right? So this is our last question. I think no, we have one more question. So obviously now, good governance is the governance which is inclusive in nature, which is transparent in nature, which is accountable in nature, uh, which is participatory in nature, right? And its sole aim should be the welfare of the people, right? So this such government has been termed as good governance. Now, in good governance, then the things that is required, the factors for good governance is, as I have already told you. Now, this is first of all transparency in the system. Now, transfer for transparency, you could write that the citizen charter has been enacted by the government. Then also write about the right to information has been there, right? To do two these things are there. Second one that is required is accountable. Obviously, the government has to answer it, and we have a grievance redressal mechanism that has been there, right? We could go to any tribunal, we could go to any other places, right, pertaining to the things that are not given by the government, right? So obviously accountability stands there as well. Apart from the third factor, that is inclusivity, right? Now the government has taken several methods, there are several steps for poverty alleviation, right? For for increasing entrepreneurship among the youths, right? Obviously giving a reservation to the downtrodden, the social castes and tribes and all, right? So there have been different mechanisms that has been done to ensure this inclusivity in this. people participation, right? So obviously the government to the government, you know, there should be that the people should participate in policy formulation. Their views are often asked by the government that you could give your views regarding this, right? Now we could raise the issue anywhere. So obviously people participation is obviously required and a factor for which is good governance as such. Now for the next is after with better grievance redressal, as well as basically everyone the feeling of, you know, a unity and integrity between the government and the people, right? So the government should understand the people a part of their own mechanism. That is also required for good governance. Now, the next part says is what are its challenges? Challenges is lot many. Now, the first one is, but before going to the challenges, we will talk about some of the steps. Now, this was one thing that most of the students missed in their answer. Now, the steps taken by the government in this regard. First of all, you will write citizen charter, right? Then RTI, right? Now, obviously, e-governance, right? E-governance is there. Now, apart from this grievance redressal mechanism, so these four steps have been taken, right, by the government for ensuring good governance, as well as the public awareness program about the things, right? So give five things as the steps taken by the government out there. Then you will come to the challenges. The challenges is rampant corruption, right? Corruption and intransparency in the system, right? This is the first challenge. Second one is red tapeism, right? Too much, uh, too much laws are there, which is very difficult to, get rid of. And this is one of the uh, problem of ease to doing business or even in other field, right? So even for getting a passport or getting a driving license, you have to go through such a cumbersome, things that makes the things, very difficult for us. Now red tapeism is there. Now there is a lack of people's participation in the government. People is basically, it is said that obviously the people participation should be there, but nowhere participation is there. In case of next challenge is the citizen charter, right, which says the timely delivery of services and the things. It is basically it has been used as ununiform way. Why it is ununiform way? Because the different organizations needs are different, right? So these should be charted in another way, right? So they nearly follow the same procedure and same things like that. So this is one thing. Now lack of inclusivity is there, right? Because we see that if we talk about the representation in the government from the lower strata, it has still been a very low, right? So this is what the challenges are. Now, how good governance could be attained? So obviously by mitigating these challenges, by making the system more transparent, by making the system more accountable, by promoting e-governance, by promoting RTI, giving power to RTI. It is happening that most of the organization, they always keep the important information as a classified one, and they are not giving it to the people, which is against the good governance as such. That should be there. The people representative should be made more responsible. Now another one is we should have strict law against corruption. The authorities should be keeping an eye on all those people involved in this, and also these all the things are to be written by you. Now we will come to the last question. Examine the right to life in the Constitution. of India and different dimensions attached to it. Now, if we talk about right to life, it is enshrined in Article 21 of the Constitution, and it is a sort of absolute right, right? Because it can't be infringed even in the case of emergency. Now, right to life has been interpreted that a person has the right to life in the sense he needs a roti, kapda, and makan. Right? That means he needs food, shelter, and clothes. This was the basic thing, and it was as per the procedure established by law, which we have taken from the Japanese constitution as such, right? But in fact, basically, in the Menka Gandhi case, Menka Gandhi versus Union of India case 1978, it was basically first time when the Supreme Court came out with its verdict on Article 21, and it said that the right to life doesn't mean the physical survival of a being. It also means the human dignity. He should survive or live with human dignity. And now this gave birth to the due process of law, which was adopted from the American Constitution as such. Now, due process of law meant that it is not what is written is to be followed, but it should also be there that whatever the essence or spirit of the thing is, that should also be kept into mind. Now, this was like a revolution because it completely revolutionized this, and a hell lot of, verdict were given by Supreme Court, and it had made a lot many things as the, it made a lot many things as the fundamental right for the people, like having clean water, having clean environment, having medical facility, the right to have medical facility if gets injured, right? Now, apart from a right to have a legal, free legal aid, obviously it has become now in a Vishakha case, obviously, right? We saw that the exploitation of women at the working, the sexual exploitation of women at the working places was barred by it. By Puttuswamy case 2017, we have the right to privacy in it, right? Then obviously we had a Navdeep Singh case, right, in which homosexuality was decriminalized because earlier we have IPC 377, right, under which any person who was found in unnatural sex, so he was obviously punished under section 377 of IPC. Right now, section 377 was removed by this one. Now it was non-punishable, right? So it has been, even recently we have now the right to forget, right? That is, right to forget is obviously what, obviously we have the right to get our data what we have furnished earlier back from even the government or the social media or anywhere else if we have stopped using that, right? So these are the things that has been done in Article 21, and it has really given a great shape, right? It has really given a great shape to our constitution and had made really a strong voice for the real rights, the fundamental rights of the people, right? And this is what you need to write in this article, in this question as such. So this was all about the test paper. I hope whatever we have discussed is going to be beneficial for you, right? Thank you guys. Thank you. morning class.